Wannan mzaha.
Good afternoon, Your Honor. The prosecution is represented by myself, Nora, J.V. Owiti,
Present, Your Honor.
Miss Sonia,
Present, Your Honor.
and Mr. Jalson Makori.
Present, Your Honor.
IPOA is represented by Miss Christine. Afternoon, Your Honor. I'm present.
Your Honor, please, my name is Julius Kuma.
For the rest comments, my name is Mr. Delta, Mr. Yvonne, Mr. Lama, Mr. Lama. Philip. He was in the forum. Yeah, thank you. Mr. Kamai, Mr. Shadrach Wambui. Good afternoon, I'm present. Thank you. Mr. Stanley Njui. Present. Mr. Geoffrey Langan. From Philip. Present, Your Honor. Philip. And Mr. Vincent. That is the team. Before you read the ruling, there's a preliminary issue that you want to talk about. It is very important so that both it's only to me. Only to me. We are not making an application for arrest. Just a small concern. Thank you.
Do you understand the defense to be asking you to arrest the ruling?
No.
If not, then we proceed with the ruling, then they can make the application. Because the only way to stop the ruling would be to arrest.
No, we are not.
Then we proceed with the ruling. We'll be waiting for them to make it.
Probably we are saying we have considered 21 days. Allow us only to effectively.
With a lot of respect, we would urge the court to read the ruling, which is the business of the day. Once we're done with the ruling, we can deal with any other matters arising therefrom or related thereto. But the court can give the guidelines.
This point, they are communal, matter of coming up to the schooling, also a way to get this time to go and section 36A3 B of the Penal Code. We add that there are no cogent and demonstrable grounds that the respondent will interfere with. He also cited the case of Republic versus Massive Debate and also the case of Republic versus William Chid and another, where he submitted that the Superior Court held that there must be cogent material before court to demonstrate action or perceived interference with witnesses by the respondent, which was lacking in the instance. Mr. Keaton further urged that in limiting the fundamental freedom for suspect, court ought to be extra vigilant in granting such orders. He referred to the case of Ramadan M. Hassan, DPP 2017 EKLR. He proffered further that the respondent has all along cooperated with the investigation. He reverberated that the respondent voluntarily presented himself by court, where he recorded a statement and later presented himself to the DCI case court. He told the court that the respondent has since been interdicted and therefore has lost police powers to interfere with the witness. Furthermore, his interdiction has set condition that he should periodically report to the authority. He urged the court to issue order that interdiction and less restrictive to the respondent. He made reference to the often cited case of Michael Rotich versus Public by Stimaro as he was then, 2016 EKLR, where the court stressed the need to protect and preserve and respect the legal right to liberty. The learned counsel adjured that the accused is not a third party. He submitted that he has a fixed abode both here in Nairobi and in Eldoret, and also that the respondent should be accorded the presumption of innocence. Finally, he urged the court to adopt the test of determining compelling reason as set out in the case of Republic versus Danford Kabake Mwangi, 2016 EKLR. He thus exhorted that the application should be signed. Mr. Langat Nani Counsel, also the respondent, reiterated that there is no evidence of interference of the investigation. This is the deponent confirmed that the investigating officer confirmed that they are in possession of the respondent's mobile phone, which the respondent has control in regards to the press analysis. He submitted that the respondent is willing and ready to abide by all the conditions of the court. In his part, Mr. Tanai, Senate Counsel, also the respondent, in reiterating that the respondent has the right to be admitted on bail or bond, also argued On the flip side, that in the unlikely event that petition without custodial order will be limited. It's on better learning council, also for the respondent, argued that the applicant has failed in the obligation to demonstrate competitive. Cited the Court of Appeal Authority of Michael Juma Oyama, but had another versus public criminal opinion number 113, where the court went at great length to define what amounts to comparing. In that matter, the Court of Appeal adopted the information as follows. Open court, the place of compelling reasons should denote reasons that are possible and convincing as to make the court feel strongly that the accused person should not be released on bail. On bond. Bail should not therefore be denied on flimsy grounds, but on freely cogent grounds that meet the high standards set by the Constitution. He enjoined that the respondent has cooperated with the investigation and that the affidavit does not enumerate witnesses. Therefore, the respondent cannot interfere with witnesses that are associated. On witness interference, he cited the case of public versus Dwight Surgery and for others, criminal case number 61 of 2021. He also cited the case of Republic versus Richard David Alden, criminal case number 48 of 2016. He urged the court to invoke Article 19, 20, 22, 3, and 29 of the. He finally submitted that there is no attempt by the respondent to respond and therefore is not a right. That supposing the applicable test set herein above in this ruling as to whether the applicant has proved compelling reason, there are 4 broad reasons that have been advanced by the prosecution as compelling reasons. So I've distilled the first one to be flight risk, the second to be safety of the respondent and public order, the third one to be the seriousness of the offense, lastly, interference with the investigation and witnesses. So on the first link on the seriousness of the offense, it cannot be underscored after the charges that the respondent is being investigated on is grave and weighty. The seriousness of offense in terms of the sentence likely to follow a conviction has repeatedly be a consideration in exercising discretion. The seriousness of offense has a clear bearing which the court ought to bear in mind on factors influence the mind of the accused or the respondent facing a charge with respect to the offense as to whether it would be a good thing to skip or not. And such a possibility is not out of question. It has happened before and in similar cases. So, in the case of Pastor was public 1991, ALR 220. I will not wish to belabor into the propriety of this game, basically because standing on its own, it cannot be a ground to deny it before, but ought to be fortified under nothing but other factors. That was stated in the case of the public was Zachariah of Waterbardo, 2018 EKR. Similar in the case of Salim Said Nasoro and 2 others, High Court, Nairobi Miscellaneous Application number 326, where the court again held that the seriousness of the offense per se is not a basis for denying bail. Additionally, in the case of the public versus Sabit, Mamor, Deng, and another, 2020 EKLR, I'm not going to the site. Consequently, in the site. So additionally, in the case of the public versus Sabit, Mamor, Deng, and another, 2020 EKLR, Supreme Court held that the court. However, in the current constitutional order, murder is an offense like any other for the purposes of bail pending trial, and therefore, a bail application in a murder case, as in any other case, has to be looked at from the prison of Article 49(1)(h) of the Constitution. And the key question that takes center stage is whether the accused will turn up for trial if released upon bail. Consequently, in the premise, the fact only that the respondent will be likely to face serious charges is no reason to deny any bond. Courts have adopted innovative mechanisms and processes that ensure that this person, respondent, granted bail not abscond. Go to the next link on slide. Intertwined with the above is on the likelihood of the respondent absconding. The paramountcy when deciding the issue of bond or bail is whether the respondent will attend trial or whether there is the likelihood of absconding. It is the rule of thumb and compass that will guide the court. This has been held in a host of cases. I've cited Job Kenyanya Musoni, Public High Court, Nairobi Criminal Prosecution number 299. It has been deposed that there is a high likelihood of the respondent absconding, considering the seriousness of the offense that is likely to be charged. The foregoing ought to be deduced from the respondent's corner before his arrest. It is indubitable that the respondent voluntarily presented himself to the DCI headquarters and IPO office. It was confirmed that the respondent was not arrested in the Eldoret as earlier reported in the media. It has also not been voted that the accused does not have a fixed place of abode and he has no familiar ties. It was also considered by the deponent investigating officer that there was no presentation of material evidence to support this. Thus, the evidential fact that the respondent did not take any steps to flee the country or circumvent arrest. Real evidence is required to show that the accused is likely to go in fight and is likely to abscond. No such evidence upon which an inference may be drawn that he will abscond was presented. For that reason, this ground is not sustainable and rejected. On the third limb, on the safety of the respondent and public order, on this prong, the deponent has averred that the gruesome murder of the deceased has elicited widespread anger and outrage, leading to demonstration which has been destructive, and therefore safety and security of the respondent cannot be granted. Mr. Kiton, in opposing the application on this facet, has cited the case of Mercy Chepet Supra, where the Kenya J has strongly vocalized himself in no uncertain terms that at this time and age, such ground cannot meet the threshold of compelling reasons. The judge goes further to correctly state that it is the duty of the state to provide safety and security to the citizen. This position find fortification in the case of Republic vs. Mjirwa, criminal case number E001 of 2024, where the same learned judge that is espoused by open court. This court's view is that the ground that the security of the accused is threatened by the members of the public or family of the deceased should never be encouraged as a ground for denial of bail, unless there is real evidence of actual threat, lest we should inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. End of quote. Flowing from the foregoing authorities, I therefore find the argument that the respondent came for his own safety and security without real evidence to be circumvented, without legal factual basis. In fact, to address the other tenant, I take judicial notice that demonstration and protest are going despite the fact that the respondent is. On the last limb, on interference with witnesses and investigation, the prosecution alleges likelihood of interference with prosecution witnesses and investigation. This is the most potent ground. Is the prosecution's allegation of likelihood of interference with prosecution witnesses as such amounts to an affront to the administration of justice, thus a justifiable reason to limit right to liberty. In also an open cited case of R. vs. Captain Mayende, three others stated, open court, in all civilized systems of court, interference with witnesses is a highly potent ground on which the accused person may be refused bail. It is a reasonable and justifiable limitation of right to liberty, law, in an open and democratic society as a way of safeguarding the administration of justice. Undoubtedly, a cardinal tenet in criminal justice, social justice, and the rule of law in general, as envisioned by the people of Kenya in the preamble of the Constitution of Kenya 2010. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amount to interference with witnesses, an impediment to or perversion of course of justice. If the interference is aimed at impeding, perverting the course of justice, and if it is so found, it is a justifiable reason to limit the right to liberty of the accused. End of quote. I've also cited the case of R. vs. Fashes Shobi that affirmed that the proven interference with witnesses is an affront to the obstruction of justice, and therefore a compelling reason as contemplated by Article 49, Article 1 of the Constitution. Accordingly, the specific instances of or likelihood of interference with witnesses must be laid before the court with such succinct, detailed evidence in support thereof as to persuade the court to deny the respondent bond on this ground. It was initiated in the case of R versus Floyd surgery, I quoted here earlier, Supra, and I quote, for the prosecution to succeed in persuading the court on this criteria, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of threats or threats to witnesses, direct or indirect, incriminating communication between the accused and the witnesses, close familiar relationship between the accused and the witnesses, among others. It is therefore incumbent that the prosecution needed to demonstrate with tangible evidence of the actual interference or likelihood of interference. After the case of Richard David Allen, who you cited, the court must therefore strike a perfect balance to ensure that the trial is not impeded by acts of interference with witnesses, but at the same time uphold the rights of prisoners. This was held in AKK versus Public 2017 EKLR. The common ground in the Easter case is as follows: is that the respondent is the officer commanding police station, Central Police Station. That is not in doubt. It can also not be left doubt that Central Police Station is the scene of crime according to the investigating officer. It is also not indubitable that the respondent is a senior ranking officer in the National Police Service in the rank of the Chief Inspector of Police. It is also not in dispute that the majority of the witnesses, according to the investigating officer, will be police officers who at the time of the commission of the offense were serving under the command of the respondent. Corollary, the respondent wields significant influence and or camaraderie with the said witnesses with the likelihood of contacting them, thereby jeopardizing the investigation entirely.